How much time should you be preparing for hearings? There's two types of hearings here in New Mexico. There's a summary hour hearing where you're just giving legal argument. Only the attorneys speak, no evidence is presented. Usually it's about 30 minutes. It could be up to an hour. Generally, you're going to take the full 30 minutes to an hour preparing because you're doing research, you're reviewing the pleadings, you're drafting your oral argument, and any potential rebuttal argument. You're having that ready before your hearing prior, and you're also looking up any procedural history of the case. If it's an evidentiary hearing, you're probably going to spend, for instance, if it's a 3-hour evidentiary hearing, you're going to need at least those 3 hours to prepare your direct examination questions, to walk your client through the direct examination, to walk your client through potential cross-examination questions, to prepare cross-examinations of the other witnesses, any direct, depending, I mean, it could really go on. You're going to spend at least the time needed for your preparation. The reason you need to know how long it is going to take you to prepare for a hearing, go watch my other video that I just posted, is because not only for scheduling so that you can calendar yourself appropriately to block that time off to do all of those things prior to the hearing, but so that you can also give your client a heads up as to how much this is going to cost them. So again, if it's, for instance, a 1-hour hearing, you're probably going to spend at least a 1 hour preparing. If it's a 4-hour evidentiary hearing, you might spend even more than 4 hours preparing, depending. I generally say for legal argument hearing where there's no evidence, it's at least the time of the hearing. For an evidentiary hearing, it can be about 1.5 to 2 times that. So get yourself an estimate ahead of time, be diligent about it, calendar yourself those blocks to work on, calendar a preparation meeting with your client, and let them. So you're about to have a hearing and you don't get to have any evidence, you don't get to have any testimony, what are you supposed to do? This is how in New Mexico we do it. It's called a summary hour hearing when there's no testimony or evidence or witnesses, exhibits allowed. You are only allowed to bring legal argument to the court. Generally, the first person who does the motion goes first. The second party gets to respond, and then the first party that presented the original allegations rebuts anything that was said that was not brought up in the initial argument. So hopefully you have prepared the motion with as much, or the response with as much legal argument, support, statute, case law, so that when you go to prepare, what you're doing is you're taking all of that and you're writing it out or typing it out into an oral presentation to the judge. It should last probably no more than 10 minutes. It should be strong.